Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday. It was a long week. We got a lot of work done this week. My background just changed and it's something, I don't even know what it is. Hold on, I just see a bunch of purple puffy stuff. I guess I'm coral reef, right? Coral reef? Anyway, we're going to start with Maricopa with my son in the background. And then we're going to go to Indiana. But first we have to get through Maricopa. Oh, you didn't see that. Hold on. Coral reef? That looks like coral reef, right? And there's Maricopa County. Yes, Anthony is screaming, yes. But at least he's not swearing. Right? He's just saying on a one. He's saying up top. All right. Here we go.
Have a seat by the door.
Correct.
Please state your name and date of birth.
Corey Michelle Baker Campbell, 8/14/1984.
You are here today on a new Superior Court case.
Yes.
There are allegations that you had dangerous drugs in your possession, which is a Class 4 felony, and drug paraphernalia, which is a Class 6 felony. This court did find probable cause and has appointed an attorney to assist you. Your next hearing will be on August 7th at 8:30 in the morning. That is a status conference for these new charges. Because you are already on felony release, you are not eligible for release today. And so an evidentiary hearing has been set for you for August 8th at 1:30 in the afternoon to discuss that. And you'll have an attorney there as well. All of this information is on your paperwork. Please step to your left. Okay. Okay, and we are going to deviate just one moment, please. Thank you. We're going to call Amy Driver to the podium. Amy Driver. And then after that will be Rick Morgan. Thank you. Please state your name and date of birth.
Amy Renee Driver, June 10th, 1981.
Thank you. And I believe you have counsel appearing today. Counsel, would you like to announce? I believe you're muted.
Damn mute button.
Okay, they're going to call right back in. Just one moment. Let's see if they can do it. Okay. Counsel, would you like to announce?
Yes, thank you, Your Honor. Ron DeBrigida for Miss Driver.
Thank you. She's here today on a new Superior Court case. There's allegations of dangerous drug use, Class 4 felony, drug paraphernalia, Class 6 felony, burglary, possession of tools, Class 6 felony, and theft and control of property, which is a misdemeanor. Counsel, would you like to be heard on probable cause?
Your Honor?
Yes, sir.
Can you hear me okay?
I can now. Would you like to make a statement about probable cause?
Yes, Your Honor. I was able to review the form. Hello?
Oh, you're cutting in and out, sir. I cannot hear you now.
Okay. I'm sorry. 1 second.
What a mess. Don't worry, he'll fix it. He wasn't cutting in and out. He could have just kept talking.
And I see the state has joined us. We are on Miss Amy Driver. Her counsel is about to appear.
Yes, Your Honor. The state is present for this case.
Okay. Is counsel for Ms. Driver on the call? Okay, we'll try it again. Counsel for Ms. Driver, are you now on the call?
OJ's going to finish before this little hearing is.
Hello.
Yes,
I'm sorry,
we
Your
can hear
Honor. Is
you
that
now.
any better? Okay,
It
my
is.
apologies for the technical difficulties. So with respect to the Form 4, which I did have an opportunity to review, I'll note that many of the issues related to the controlled substances, there's no confirming lab tests that I saw, not even any kind of field test. So I don't know that we have probable cause for those items at this point.
Okay. And for the state, Ms. Stetson, did you want to appear on this matter? Ms. Driver?
Yes, Your Honor. The state is appearing. For the record, Ashley Stetson on behalf of the state.
Okay, and did you have an argument as to what the council stated, not having a field test?
Yes, Your Honor. The state does believe that there was a field test done. I do believe it's at the bottom of the Form 4. State did see something about it testing positive for methamphetamine. I'm trying to find it really quickly. It does say, it says, also in the purse, officers located 3 small dime baggies with a crystalline material in 2 of them and residue in the 3rd. Officers identified this as packaging, dangerous drug methamphetamine. The first bag weighed 1.2 grams with packaging and the second being 0.9 grams with packaging. They were tested with the True Narc and showed positive for methamphetamine.
Okay, thank you for pointing that out. So I also read the Form 4. I did find probable cause on all the allegations. However, this is not a hearing on the merits. That would be at the next hearing. You have an attorney, it sounds like. Sir, are you going to be her attorney of record going forward, or should I still appoint a public defender?
No, I'll continue to represent Ms. Driver.
Okay, let me go ahead and edit that. One moment, please. Okay, I have now added you to her release so that that will be included. So this court did find probable cause. You have an attorney that you've hired. Your next hearing is August 7th at 8:30 in the morning. That is a status conference to discuss these allegations. Because you are already on felony release, by statute, this court cannot release you today. However, you will have a second hearing, which is the evidentiary hearing on August 8th at 1:30 in the afternoon. So that is the information I have to provide today. Does counsel for Ms. Driver wish to say anything else?
Judge, I just know that Ms. Driver, I've known her for some time, and I know she has ties to the community. She's always been very reliable. She shows up for all our court appearances. She's engaged with her defense. And I think she's a minimal flight risk.
Thank you. And this court would consider that, unfortunately, because she is on felony release, that is not an option for us today based on, and it is Arizona Criminal Rules of Procedure 4.2A7A. But I do appreciate those arguments, and hopefully at the evidentiary hearing, you'll be able to make them again. Anything else from the state?
No, Your Honor. Thank you.
Okay, thank you. This will all be on your paperwork. Please have a seat.
And Judge, if I may,
Yes?
I don't mean to take up too much of the court's time, but I know Ms. Driver was trying to call my office today. I wasn't in my office, but I was made aware of her attempts to call. May I provide a number that she is able to call to make free legal calls to?
I think that would be all right. Do you need a piece of paper?
No, just very quick.
He said to make free legal calls too. Ha ha. We all need free legal calls, don't we? Just kidding. Don't call this number. Don't. Just don't.
Yeah.
No, well, I'm asking that they
Forget it.
continue.
I'm muting it now.
Okay, she's ready to go. Please state the number.
623 0.
Okay, thank you very much, and you may be excused. Thank you.
Thank you, Your Honor.
Okay, the next person to come, please, is Rick Morgan. After that will be Jarrell Davis. Have a seat by the door. Jarrell Davis. Please state your name and date of birth for the record.
Rick Morgan, 8/15 of 1982.
Thank
What is
you.
he
You're here
holding?
today on an out-of-county warrant. It appears that the warrant came from, let's see, Pinal County, and it's a probation violation warrant. We won't discuss the underlying charges. Because of that warrant, you're not eligible for release today. An attorney will be appointed for you at your next hearing. It is August 6th at 8:30 in the morning at Pinal County Superior Court. This information will be on your paperwork. Okay.
Got it.
Jarrell Davis, please come to the podium, and then after will be Jeffrey James Gillett. Is Jarrell Davis available? Davis? He's going to be a house call? He is going to be a house call. Is the same for Mr. James Gillett? Yes. Okay. So for the state, I apologize. I know you wanted to appear on both those matters. I was not aware there would be house calls today. Reason? We can ask for a reason.
Hi, Summary.
High profile, so it's going to be towards the end. So they're not house calls, they're just going to be at the end? Right, so they're certainly like how separate people we're going to be. Okay. Ma'am, would you like to? Okay, all right, and feel free to go ahead and mute your camera and we'll go through the rest of the list. Okay, Hector Begay, please come to the podium. And then Kelvin Jones, have a seat by the door. Hector Begay and then Kelvin Jones. Please state your name and date of birth.
Hi, ma'am. That's Hector Ray Begay, August 2nd, 1986.
Thank you. You're here today on a new Superior Court case. There's allegations that you committed aggravated DUI, which is a Class 4 felony, and dangerous drug possession or use, which is a Class 4 felony. This court did find probable cause and has appointed an attorney to assist you. Your next hearing is August 7th at 8:30 in the morning, and there is a cash-only appearance bond set for you at $10,000. If you make that bond, you will have pretrial supervision with random drug and alcohol testing so you can prove your sobriety between now and your next hearing to the judge.
August 7th, right?
It is August 7th, and yes, and that's all on your paperwork, the address, as well as the time and
I'm
location.
alive.
Okay.
I'm
Thank
very
you.
alive. Summary disposition.
Kelvin Jones, please come to the podium. Robert Crow, have a seat by the door. Please state your name and date of birth.
Calvin Jones, 8888.
You're here today on a new Superior Court case. It was
What a birthday. 8888.
alleged that you discharged a firearm within the city limits. That is a Class 6 felony. This court did find probable cause and has appointed an attorney to assist you at your next hearing. It will be downtown on August 7th at 8:30 in the morning. A secured appearance bond is set for you at $10,000.
Okay.
If you make that bond, do not return to the scene of the alleged crime or have any contact with the alleged victims, witnesses, or complainants. Also, no alcohol between now and your next hearing.
Yes, ma'am.
All of this will be on your paperwork.
For sure.
Okay.
Thank you.
Robert Crow, please come to the podium. And then Jesse Hinkle, have a seat by the door. Jesse Hinkle, please state your name and date of birth.
Robert Eugene Crow, 01/24/1969.
Thank you. You're here today on a new Superior Court case. It's been alleged that you had narcotic drugs in your possession, which was a Class 4 felony. Probable cause is found and an attorney has been appointed to assist you. Your next hearing is downtown on August 7th at 8:30 in the morning. A secured appearance bond is set for you today at $7,500. If you make that bond, please follow the release conditions on your paperwork. Okay. Jesse Hinkle, please come to the podium. Jesse Hinkle. And then after that, Joseph Cromwell. Joseph Cromwell. Please state your name and date of birth.
Jesse Hinkle, 08/21/1993.
You're here today on, looks like 3 matters. The first one is a new Superior Court case where it was alleged that you had dangerous drugs, which is a Class 4 felony, narcotic drugs, Class 4 felony, drug paraphernalia, Class 6 felony, and then you had several misdemeanors: false reporting to law enforcement, obstruction, not giving the true name, and knowingly displaying a false license plate. This court did find probable cause and has appointed an attorney for you for your next hearing on August 7th at 8:30 in the morning. On your new case, it is a secured bond set at $2,000. Your next case is a probation violation warrant where you are alleged to violate terms 3 and 5 of your probation. An attorney has been appointed for you. Your probation hearing will be on August 8th at 8:30 in the morning. Bond is set in that case at $200. On your last case, it is a new Superior Court arrest warrant. This comes from a direct complaint where the allegations of criminal activity occurred back in 2024. So this is December of 2024. It's 4 different counts of shoplifting, which are Class 4 felonies. On this direct complaint, you have a hearing coming up on August 7th at 8:30 in the morning. An attorney has been assigned to assist you, and your bond is $5,000 secured. So altogether, that's $7,200 secured. If you
Monica, thank you so much. Thank you. I appreciate it. All right, now I've got to look to see who got a membership, and when I click the tab over, it's probably going to play my intro music. All right, now I've got to look to see if it didn't. At least, there we go. Now I can see.
you do make that bond, be sure to follow the release conditions, and that includes, and I did not put them on this paperwork, make sure to contact your probation officer. So let me make sure that's on there here. So you need to contact your probation officer within 72 hours of release. So I'm just changing number 34 to make sure that has that in there. Okay, but that applies in all your cases. You need to call your probation officer. So one of his will need to be replaced. Okay, if you'd like to have a seat, sir, all this information will be on your paperwork.
Okay.
Okay, thank you. Joseph Cromwell, will you please come to the podium? And then Mr. Christopher Bulahanis, have a seat by the door. Please state your name and date of birth.
Joseph Cromwell, August 2nd, 1994.
Thank you. You're here today on a new Superior Court case. It was alleged that you committed aggravated assault, which is a Class 3 felony, as well as aggravated driving the wrong way, Class 4 felony, criminal damage, Class 4 felony, and endangerment, which is a Class 6 felony. This court did find probable cause and has appointed an attorney to assist you. Your next hearing is August 7th at 8:30 in the morning downtown. There is a cash-only appearance bond set for you at $5,000. If you make that bond, you will have pre-trial supervision, including random drug and alcohol testing. And that's really important for you because you can prove your sobriety to the next judge by going to the random testing. Okay, there are some more conditions of your release. They're all printed on your paperwork. The most important one is not to have any contact with any alleged victim, witness, or complainant. Okay, this is on your paperwork. Christopher Bulahanis, please come to the podium. Herbert Claude, have a seat by the door. Herbert Claude. Please state your name and date of birth.
Christopher Bolahanis, June 14th, 1998.
You're here today on a new Superior Court case. It was alleged that you had narcotic drugs in your possession, which is a Class 4 felony, and drug paraphernalia in your possession, which is a Class 6 felony. This court did find probable cause on those two allegations. There was also alleged that you had a weapon in a drug offense, which is a Class 4 felony, and then disorderly conduct fighting, which is a misdemeanor. This court did not find probable cause for those allegations. However, the state may still provide new or additional evidence before your next hearing, and they may still be charged. So don't think that they are dismissed. It's just today there is no probable cause on the information that I read. So your next hearing is on August 7th at 8:30 in the morning. An attorney has been assigned to assist you. You can always hire your own if you'd like, but there will be one there for you. Your secured appearance bond is set at $1,500. If you make that bond, make sure to go to your hearing and follow your conditions of release on your paperwork.
Okay, thank you.
Okay. Herbert Claude, please come to the podium, and then Christian Rodriguez, have a seat by the door. Oh, and I did have to say one thing. I'm sorry. Can you switch spots one time? Mr. Cromwell, please come back. Or not Cromwell, Bulahana. I apologize. So I did have to let you know that a victim statement was provided in this case, and this court did read it, reviewed it, and considered it. So that just needs to be told to you as well, that there was a victim statement in your case.
Okay.
And it was considered. Okay, that's all.
Thank you, ma'am.
All right, Mr. Claude, thank you for your patience. And then Christian Rodriguez, have a seat by the door. Please state your name and date of birth.
Herbert Claude, 9/24/92.
Thank you. You're here today on a Superior Court probation violation warrant. It was alleged that you violated terms 3, 4, 5, and 15 of your probation. An attorney has been assigned to assist you at your probation revocation arraignment, which is on August 8th at 8:30 downtown Superior Court. There is a secured appearance bond set for you. It is $1,000. If you do make that bond, make sure to call your probation officer within 24 hours because you are on IPS. All of that is in your paperwork. Thank you. Christian Rodriguez, please come to the podium. Alejandro Rodriguez, have a seat by the door. Please state your name and date of birth.
My name is Christian Rodriguez. My date of birth is 08/03/2005.
Thank you. You're here today on a new Superior Court case. It was alleged that you had theft or control of stolen property, which is a class.
Yeah, my man is wearing an Oracle shirt, guys. I'm so happy. Nerd.
Class 6 felony, as well as carrying a deadly weapon, which is a misdemeanor. This court did find probable cause and has appointed an attorney for you. Your next hearing will be August 7th at 8:30 in the morning. There is a secured bond set for you at $1,000. If you make that bond, you will have pretrial supervision. So there'll be a phone number for you to call, and then they will assist you either with reminders or a bus pass, some way to assist you to make sure you go to your next hearing. If you fail to attend your next hearing, they will issue another warrant for your arrest, and the bond will be higher. Okay, all that's on your paperwork. Please stay.
All right, thank you.
Alejandro Rodriguez, please come to the podium. Derek Massey, have a seat by the door. Derek Massey, have a seat by the door.
Good afternoon.
Hi. Please state your name and date of birth.
Elijah Rodriguez, 4/17/2007, ma'am.
Okay, and I apologize that I mispronounced your name.
No problem, no issue.
So it looks like you're here on a new Superior Court case. There is allegations of theft or control of stolen property, which is a Class 6 felony, as well as carrying a deadly weapon and failing to admit that, which is a misdemeanor. This court did find probable cause and has appointed an attorney to assist you. Your next hearing is August 7th at 8:30 in the morning, and a secured bond has been set for you at $1,000. If you make that bond, make sure to follow the release conditions, including no weapons at all. Even ones that are simulated, like a BB gun or something, don't have it. Also, no alcohol, right?
Perfect.
Okay, all of this is on your paperwork.
All right, thank you. Have a nice day. God bless.
Thank you. Derek Bryant Massey, please come to the podium. Michael DeHart, have a seat by the door.
Hello.
Please state your name and date of birth.
Derek Massey, 1389.
You're here today on a failure to appear bench warrant. It appears that you didn't go to your comprehensive pretrial conference back in November of 2024.
Yeah.
So they issued a warrant for your arrest. You have an attorney in that case. Your next hearing will be August 11th at 8:30 in the morning. There is a secured bond set for you, and it is $1,000. If you make that bond, follow the release conditions, and go to your hearing, or they will issue a higher bond warrant for you again.
Okay.
All right, all this is on your paperwork.
Okay. Thank you.
Michael DeHart, please come to the podium. Michael Olivares, have a seat by the door. Michael DeHart. DeHart. Okay, Michael Olivares, please come to the podium. And then Scott Jackson, have a seat by the door. Please state your name and date of birth.
Michael Oliveris, 11591.
Thank you. You are here today on a, you don't look the same. Michael Olivares, 115-1991. Okay, they gave you something else to wear. All right, this is all right. You're on a municipal court warrant here. And it looks like, what happened? Is that right? It does not look right.
That's what I kept thinking, it wasn't right.
Yeah.
Sarah, you don't even know what
One
she's
moment.
talking about. Could you imagine getting in front of a judge and then her getting to your paperwork and saying, wait a second. That's, I would be pooping in my pants right now. What do you mean? Oh my God, you're going to get me for murder, aren't you? Aren't you? So getting me for murder, when I was growing up, you know, my sisters were freaking criminals and their boyfriends were all criminals. Okay. And I always had a warrant out for my arrest for this or that or this or that. And it was a legitimate fear of mine growing up as I was, you know, in my teens and 20s, that I had a murder warrant out for me. Like I'm going down for murder. I know I'm going to jail for the rest of my life. One of these days, I'm going to jail for murder, and there's nothing I can do about it. I never killed anybody. So yeah, when I was younger, that was a legitimate fear of mine. I thought I was going to jail forever for murder. I was just waiting for them to pick me up.
Please, if you take a seat, we'll figure this out.
Thank you.
Thank you. That's very strange that they would have the same birthday. Okay. Scott Jackson, please come to the podium. And then after that, Matthew Gray, have a seat by the door. Please state your name and date of birth.
Scott Jackson, 3/17/19.
What do you think he did? What do you think? Let's pick his crime before he talks. Go on. I'm going to go missionary style on this one. I'm going to go DUI. What do you think? Come on. Oh, cats are just ruining my blinds. They're just right beside me and I can't do anything because I'm in a live stream. I got my duster air. Ah, it works. I didn't hit the cat with the air. I sprayed the air in the air. The cat heard the noise from way over there and ran. FTA? Ooh, don't do that. Jeez, I almost clicked the wrong thing. So we have FTA, pooped in public, and I say DUI. No one else? Window tint. I got in trouble for that. I had to pull it off. The last time I was pulled over just a little bit ago, I had to pull my window tint off. I hate living up north sometimes. I loved that window tint. Oh, well. Okay, here we go. Let's see.
68.
You're here on a justice court warrant. And this warrant is from, let me tell you, West Mesa Justice Court. It's initial arrest warrant for DUI with more than .08. So that you did not go and have this taken care of yet.
Oh my
so
gosh,
you need to go.
I was wrong and you were right. Anna Banana. I said DUI. Anna said failure to appear. Anna nailed it. It was a failure to appear for a DUI.
An attorney will be appointed to assist you. Your next
Anna.
hearing is West Mesa Justice Court.
Anna, we would be an unstoppable team. You know that. We got each other's back. Together we could change the whole world.
August 6th at 8:30 in the morning. There is a secured bond set at $500. If you make that bond, make sure you go to your hearing and don't consume any alcohol between now and your hearing date. Okay, all of this is on your paperwork.
Okay.
All right. Matthew Gray, please come to the podium. Julio Gutierrez, have a seat by the door. Please state your name and date of birth.
Matthew Michael Gray, 8/30/78.
Thank you. You're here.
This one's a little harder, I'm thinking. I'm going to go with possession, but not with intent to deliver. I'm just going to go with possession on this one. I don't think it's I'm going to say not violent crime because, look, these guys don't care about him right now. Kelly says weed. Oh, JK says shoplifting. That's a good one. Michael says pot. Donald says meth. Ooh, Fozzie says trespassing. Salty said Miss Child Support payments. Lori said drunk in public. Okay, here we go.
Today on a new Superior Court case. They have alleged that you had theft of credit cards, which is a Class 5 felony, fraudulent use of those credit cards, a Class 6 felony, and then theft of control of stolen property, which is
okay. We weren't close peeing while jaywalking. We weren't close, but the person who got the closest, JK, you know you're criminals. We're giving that to JK.
a misdemeanor. This court did find probable cause and has appointed an attorney to assist you at your next hearing, which is August 7th at 8:30 in the morning.
Okay.
You have a secured appearance bond of $500.
That was the best.
If you make that bond, make sure not to have any contact with the alleged victims, witnesses, or complainants, and go to your hearing. All of this is on your paperwork.
Thank you.
Are they able to figure it out? They're calling to in the back. If there's another person? Okay, that makes sense. But he said that he did, but the picture is different. Yeah. Very different. Let me just check.
I don't know. Can you buy pot with a credit card? You got a credit card in your hand. You're walking down the street. Can you just buy? Don't they take cash? Okay, maybe that's a stupid question, but I would think you would have to pay cash for drugs on the street, wouldn't you? Because I see them, they all have those big bags of cash and they're all in their homes counting all that cash. So I don't know, because if it's Apple Pay or if it's credit card, isn't there like a trail? I don't know if they take Venmo. I don't know. I don't know if you could just go out into the street and buy drugs with Venmo or Cash App. Yo, let me PayPal you that. I think you need cash. I don't know though. I don't know.
I didn't hear the first case. I'm not sure if you said that first case.
Let's let them answer first, and then we'll go back. Okay. Julio Gutierrez, please come to the podium. Estrella Perez, have a seat by the door. Please state your name and date of birth.
Julio Gutierrez, 22791.
Thank you. You're here today on a probation violation warrant. It was alleged that you violated terms 3 and 5 of your probation. You do have an attorney assigned to assist you at your next hearing. It will be on August 8th at 8:30 in the morning. You do have a secured appearance bond.
Does anybody know what his shirt is? Is it a video game? Is it a car part? Is it a food? Like, what are these? Does anybody know?
Available to you at $250. If you make that bond, make sure to call your probation officer within 72 hours. You have other conditions of release, they're on your paperwork.
Okay.
Okay.
Thank you.
Estrella Perez, please come to the podium. And then Joshua Kirkwood, have a seat by the door.
Hello.
Please state your name and date.
Estrella Perez. Oh, it's cold, sorry.
And your date of birth.
8593.
Okay, you're here today on a new Superior Court case. It was alleged that you had narcotic drugs in your possession, which is a Class 4 felony, and then drug paraphernalia, which is a Class 6 felony. This court did find probable cause and has appointed an attorney to assist you. Your hearing will be August 7th at 8:30 in the morning. There is a secured appearance bond set for you, and it's $250. Because it's a new case, you are going to be subject to pretrial supervision if you make that bond.
Okay.
Okay, all of this is on your paperwork. Make sure to follow the no contact orders that are included as well.
All right.
Okay, please step to your left. Okay, so is Michael DeHart now available? Michael DeHart. All right, please state your name and date of birth.
Michael DeHart.
This one looks really tough. I don't think it's DUI. I don't think it's domestic violence. Ooh. Ay, 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 ay. I'm going with, Kelly says pimp. I'm going with intent to deliver. I'm not going with just possession this time. I'm going with delivery. Assault? Maybe. Actually, maybe. Domestic violence? Maybe. Definitely something involving violence. Domestic violence. Damn, you guys all think the road rage assault. You guys all think he beat someone up. Look, he's elderly, guys. He's almost as old as me. He might not be able to assault someone anymore. I'm going to go with intent to deliver. I'm going to go with drug dealer.
36-9.
Okay, you're here on an out-of-county warrant. It appears that Pinal County would like you back, and so they have set a bond for you of $750. You have counsel to be appointed for you at your next hearing there, and that's in Pinal County Superior Court on August 6th at 8:30 in the morning. This is all on your paperwork. If you do make bond, please go to that hearing so they don't keep issuing more warrants.
Okay.
Okay, it's all.
I got another question for you there. How do I get everything that this state has got on me?
Okay. That's not helpful. Terroristic threats. That's not helpful. Okay, so extradition. They need to extradite him to somewhere else. Okay, how do I get everything the state has got on me? It still could be intent, and it still could be domestic violence, but it's probably not forgot to use turn signals, Donald. I'm sorry. It's just, maybe it is. All right, let's see if they freaking say it.
They'll run a warrant check.
Yeah, I want it all at one time. So I'm tired of this headache.
I know that before they release you from here, they run your name to see if you have any other
But
warrants.
that's costing me every time they do that.
Okay.
If I pay a $1,500 bond, as soon as I pay that bond just disappears. Money's never there because I got a hold for another county. If I pay the $3,500 that they got on me or the $2,500 they got on me, I lose that.
Mm-hmm.
That's how they're making the money. I want it all put together, and let's get this over with so I can get back to my family.
Oh, is that what you want? That's what you want to happen? You committed crimes in different areas and you're mad because it's not all put together? So it sounds like what he was doing was he had two cases open, one in this county, one in this county, and he went in front of a judge in this county, and that judge gave him a bond, $1,500 bond. He paid it. Except he's got a case over here too, so he wasn't released. And his both the judge and his lawyer should have told him, "Don't you dare pay that bond until this other one is taken care of." But if he would just go and take care of his cases instead of picking them up, they wouldn't need to be bundled like your home and auto insurance. Maybe. Yeah. Come on, judge. I want them all put together. How dare you make me pay for my two different crimes at two different places, even though that's where I committed them?
I appreciate your argument, sir. I do not have an answer for you. That would be a very good question for your attorney when you go to your next hearing, or the judges who are more in charge of that. I am not.
I've never had a lawyer.
You haven't had an attorney there?
I have no attorney for Pinell County. I never went to Pinell County because I was in jail here.
Okay.
The whole time. But see, they don't show that.
Yep, they gave him a bond.
You get pulled here first, you got to do your time here, and then they pick you up.
Right.
So it's all a linger thing. It's wasting taxpayers' money.
Do you have?
They want my money.
Do you remember your case for that you were in jail for? Like what the case number was?
No, ma'am. But all I know is they took $3,000 of my money and said that they never got it.
Oh no. Okay.
Because I paid the bond to get out down there, and then I got picked up here because I was already for here. So whenever I come here, I was in jail. I was serving my time, and I couldn't go to court there.
Right. And usually when that happens,
they're supposed to take you down there, but they don't.
Right. I can, if I have record of it, which I don't, sir. I don't have that record. That's why I was asking. Do you know what your number is? Like what the case number?
No, ma'am.
So that might be something that you can talk through with your attorney, because then they can help you sort this out. And I have appointed an attorney for you down there in Pinell County.
Yeah, what I'm getting at though, whenever I was down there and they transported me back here, I came back here. They said that I had nothing in my paperwork.
Right. And so you're asking, where can I go and get this all sorted out?
I want it all put together and get it over with, because I'm tired of the headache. I'm tired of this backwards and forwards, because all it's going to do is just keep me in trouble.
Are you on probation here in Maricopa County at all?
No, ma'am.
No,
okay. I was supposed to get my first sentence for Maricopa County for all my charges before I got in trouble with Pinell County.
Okay.
They gave me 6 months I'd done 3 months in jail. I got out on bond, Project Bail bond, got out 14 days after I was waiting to be sentenced. I got a death threat. So I took my family and left state. Well, I got in trouble somewhere else, and they put a hold on me, and now that's why I'm back down here.
So I don't know the answer to you.
Okay, it's not domestic violence because he is trying to get back to his family. He took his family to another state. It is not domestic violence. What is it that? Oh, tell me your crime, sir.
Your question. I have a lot of speculation and ideas, but I actually don't know the answer to your question. I would like to say you could ask a sheriff, to run all your statewide warrants.
I've done ask that, and every time I do that, here's what they tell me: I can't give you no information.
That's unfortunate.
You have to do this. You have to do that. I can't do nothing when I'm behind bars.
Right. Exactly. So I don't know the answer to your question, sir. I'm sorry. But it is a very good question.
Well, I'm going to have to see if I can get the state then to give me a facelift, because I'm going to be an ugly old man by the time I get out here, and you ain't going to be wanting to keep looking at me.
I do not want you to come back, sir.
I don't want to come back either, but I can't get it solved if they don't let me.
Right. I understand.
Thank you for your time, Your Honor. You have a good night.
You too.
Sounds like failure to appear. Or like I'm trying to figure it out. Oh my God, Bill is here. I'm so famous. I'm so famous that other content creators just drop in whenever they feel like it. It's 5:32 a.m. where Bill is, and he's in my chat. Hey, Bill, how are you? Bill, what's this guy's crime? Everybody talk to Bill because he hates it. When he first logs in, and everybody says hi to him. He doesn't like it. Bill, you do not have to say hi to everybody personally. You are perfectly fine just saying, hey guys. Or you can say, hi, it's Kathy. I hope you're doing well. You could say that. Yeah, he dines and dashes. And you know what? That's all we need from Bill. We just need him to come in and say hello, hello, and then leave. Bill, the money's on the dresser. Just go. Oh, I'm working. I'm working here. Leave me alone.
Have we figured out Mr. Olivar? Okay.
It was just the booking number is wrong.
Okay. Thank you. Mr. Olivar, please come back. Okay. Please state your name and date of birth.
Michael Oliveris, 11591.
Thank you. So you do have a justice court warrant. Just, it might be news or a municipal court warrant. And it's for theft of control of property. It's a misdemeanor. And it's back from 2024, April 28th. So it's a really old one. And they put this out as a $500 bond. Your next hearing is in Buckeye Municipal Court on August 6th at 1 p.m. So that is, this is, you were like re-arrested while you were here for this because they found a warrant like that gentleman was discussing.
Okay.
So in order to get out, you'll have to pay the $500 security
I was just arrested a few months ago. Why wouldn't it show it then if it was from that back?
I can't answer that question for you.
I understand.
I'm sorry. So there will be counsel appointed for you though because of this bond at the Buckeye Municipal Court. So if you are not able to make the bond, they will transport you there. It's August 6th at 1 p.m. That is the next available court date for that. Okay. And this is all on your paperwork.
Okay, thank you.
Okay. Yeah, you can have a seat. Okay. For the detention officers, if you want to bring them in one at a time for the high profiles, could we do one now? And then we can take care of the others, and then we do the other one at the end?
Which one do you want?
They wanted the room to be clear.
Oh, they want the room to be clear. Okay, just making sure. All right, so Joshua Kirkwood, please come to the podium. Mercedes Porter, have a seat in the chair by the door.
I don't remember 2002.
I don't think so. I think you are right. Okay. All right, Mr. Kirkwood, please state your name and date of birth.
Joshua Robert Kirkwood, February 2nd, 1981.
You're here on a new Superior Court case. There's allegations that you had drug paraphernalia, which is a Class 6 felony. This court did find probable cause and appoint an attorney to assist you. Your next hearing is going to be August 15th at 8:30 in the morning. You will be released today under pretrial services, so that means you need to connect with them, and they will support you in going to your next hearing. If you need a bus pass, reminder phone calls, they're there to help you get there. There are other conditions of your release. Please follow them. They are on your paperwork.
Your Honor.
Yes. Are you sure you want to talk? Because right now I'm releasing you on pretrial services.
So I had an earlier trial, and it said I had $100 bond. So am I just being released?
Was it in a different hearing room here at this facility?
Yes.
Okay, so for these cases, you're on pretrial release, which means you don't have to pay something. But if you have to pay something in the other case, you still have to fulfill that, whatever that is. Are you going to be able to fulfill that?
No.
Then I need to put a placeholder in to make sure you get transported to your hearings. Is that correct?
Oh, so I haven't been able to call anyone yet
Okay.
to see if I can make the bail or not.
Okay. So normally if you had like 2 cases with me, I would give you a $50 placeholder if the other one was a large bond, like $1,000 or something,
Yeah.
just to make sure you're getting transported to your hearing. So I can do that for you today to make sure that you don't miss a hearing because you're still here.
Okay.
Okay, so one moment. I'm glad you brought that up.
And could I also say this?
Do you want to say more?
Yeah, please. I apologize. My foot, my ankle is blowing up.
You're having a medical emergency?
It's been happening, and I'm telling everyone. And
right. So the detention officers will be able to assist you. It just takes some time, and I apologize. It does take time because there's a lot of people here, but I understand that you're having an issue. Okay, let me get this sorted for you so that you don't miss a hearing, because I would not want you to do that and then have another warrant issued for you. So I'm going to put it down as, actually I'm just going to put it down as $25 as a placeholder because of the municipal bond. Is it Phoenix Court?
Yes.
Okay. All right. Thank you for bringing that up. Okay, should be ready? All right, if you'd like to have a seat, sir, they just have to reprint that. They'll bring it out to you. Okay, I need to go back in the calendar. I apologize due to some going back and forth. Benjamin Hopping, are you available to come to the podium? Benjamin Hopping. Okay, and then after that, Kara Berry. Kara Berry. If you can just wait there, you'll be next.
Are you available to come to the podium? Ma'am, he's a prisoner. He's going to go exactly where you tell him to go. No, I'm not available right now, Judge.
Next after him. Okay. Please state your name and date of birth.
Benjamin Hopping, 6/28/1996.
You're here today on a new Superior Court case. There is allegations that you had dangerous drugs, which is a Class 4 felony, also unlawful flight from law enforcement, which is a Class 6 felony, and then drug paraphernalia, Class 6 felony. This court did find probable cause and has appointed an attorney to assist you at your next hearing, which is on August 7th at 8:30 in the morning. And for the detention officer, she's trying to get your attention. So, all right, I apologize.
No, that's fine.
There is a secured appearance bond set for you at $5,000. If you make that bond, you'll be released to pretrial services. And then there are a few other conditions, including do not consume any alcohol between now and your next hearing.
I have one question about making the bond payment. Can that be done online, or do they have to go in person to do that?
So I am not familiar with the process of actually making the bond payment. But I do know they have information for you in the release area if you say...
Just like I've never had to post a bond, sir. How the hell would I know?
Like, I plan to make my bond.
Okay.
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 All right. All of this is on your paperwork.
Thank you.
Okay. Kara Bear, please come to the podium. I hope I said it right this time. Okay.
Did you give them?
So you will correct me. Please state your name and date of birth.
Kara Bear.
Yes, I am in. I am in control of their Zoom session.
722.
No, I can't get rid of it.
Thank you.
Yes.
You're here today on a new Superior Court case. It was alleged that you had narcotic drugs in your possession, which is a Class 4 felony. This court did find probable cause and has appointed an attorney to assist you. Your next hearing is August 7th at 8:30 in the morning. There is a secured appearance bond set.
I have court on August 4th for a different matter. It's not for a criminal, but it's for my apartment. And I'm also on, just now got workman's comp. And so I talked to the pretrial services, but
I know it's not, but she really, really looks like that girl from Indiana, and this is Arizona. That would be funny. That would be so funny if we got a girl in Indiana on Monday and she shows up in Arizona on Wednesday.
To make that hearing, it's in my apartment, and I got 2 dogs and an elderly lady that's there.
So this is the first available hearing is August 7th.
I can't get my money I work at FedEx, but I work with comp for my work-related injury, and I have to show up. Sedgwick just opened a claim, and there's no way that my money is like wrapped up, so I don't have family. I just have my 2 dogs and the other lady I take care of. So until I can sign for my money, I can't even get money.
Okay.
And I have to make that hearing on the 4th because it's a judgment for my apartment. There was mold exposure in my apartment, and so I have a hearing that's set. The paperwork's in my property.
Okay, I understand.
And I will go to every hearing.
Right. Let me just double check.
Thank you. I haven't been in trouble in 20 years.
And that's what I'm looking at, is there a threat to the community?
I haven't.
So, and it looks like it has been quite a while. All right.
Thank you.
So we're going to edit this. We're going to make this just pretrial supervision today. So it's called supervised release.
Thank you so much.
All right, please make sure you do go to that hearing and get this taken care of. They will issue a warrant for your arrest if you do not appear.
Thank you so much.
Just have a seat and they'll come out for you.
Thank you.
Okay. All right, Mercedes Porter, please come to the podium, and then Christopher Villa, have a seat by the door. Please state your name and date of birth.
Mercedes Porter. My birthday is March 27th, 1994.
You're here today on a new Superior Court case. There's allegations of dangerous drug possession, which is a Class 4 felony, and then drug paraphernalia, which is a Class 6 felony. This court did find probable cause and has appointed an attorney to assist you. Your next hearing is August 15th at 8:30 in the morning. You will have supervised release, which means you definitely need to call them and have them help you get there. Also, no weapons and no alcohol is on your release conditions. Okay, please step to your left. Christopher Villa, please come to the podium. Nicholas Vaught, have a seat by the door.
Hello, Miss.
Please state your name and date of birth.
August 25th, 1988. Oh, Christopher Villa.
Okay.
I'm sorry.
You're here on a new Superior Court case. It's alleging theft or control of stolen property, which is a Class 6 felony. This court did find probable cause and has appointed an attorney to assist you. Your next hearing is on August 15th at 8:30 in the morning. This court would like to release you under what's called supervised release. So that means there'll be a phone number for you to contact or connect with. They will assist you in getting to your next hearing. Make sure you take advantage of that. Your release conditions include no contact with the alleged victim, witnesses, or complainants. So that means the people who, you know.
Okay.
All right, so no contact with them. Make sure you keep up to date with your court address. What would you like to say? Because I am releasing you.
Oh, no, I just had to raise my hand. I'm sorry. I was gonna ask, never mind.
Okay, because remember, you have the right to remain silent.
Yeah.
You said all you had to today, your name and your date of birth.
Okay, I'm sorry, Miss.
It's okay. All right, all of this is on your paperwork. If you have questions, read through your paperwork. You will have an attorney to assist you at your hearing. Ask them your questions.
Okay, Miss.
Okay.
Okay. Have a good.
Nicholas Vaught, please come to the podium. Krista Flores, have a seat by the door.
How are we doing, ma'am?
Please state your name and date of birth.
Nicholas Vaught, it's gonna be 2/15/96.
All right, you're here today on a municipal court warrant. It appears, let me look again. Okay, this is a post-adjudication warrant, meaning you haven't paid your fines and fees for a DUI that you went to trial on.
Okay.
All right.
Oh, sorry.
Okay, so this is a misdemeanor because it's a failure to pay. This court's not able to appoint you counsel in this type of case because it's a misdemeanor.
Yes, ma'am.
You do have a hearing coming up in Goodyear on August 20th at 1 p.m. I've included their phone number for you on your order because I would like to release you today with the promise you're going to go get this taken care of.
Yes, ma'am.
You either go to the hearing or
He's here because you rolled in that one.
you call them ahead of time and just get it taken care of.
Yes, I called and got a continuance and it didn't happen and here we are.
Here we are, right.
So, yeah, I will make sure this is handled.
Okay, follow through. This is all on your paperwork. Please step to your left.
Thank you. You have a wonderful day.
Krista Flores.
One person should have understood that. One person. I said he's here because he rolled in Nat 1. Not one person understands that. Not even Maiko. All right, let's go. Let's calm it down a little bit and go to Indiana. Yep, Indiana. I'm going to fast forward this first guy, though.
Are you under the influence of any?
Hold on. I'm going to fast forward the first guy. Don't worry, there's plenty more where this came from.
64 DO2 2507 F2 8143. Defendant appears in custody by video from the Porter County Jail. Defense counsel Henson appears via Zoom representing the defendant for the limited purpose of Rule 2.6 bond hearing. States present by Deputy Peterson. We're set for an initial hearing today, Judge.
Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What is your name?
Christopher James Hill.
How old are you?
I'm 29 years old, Your Honor.
Do you understand English?
Yes.
Are you under the influence of any drug or alcohol?
No.
If there's ever a time where you can't hear or understand anything, will you let me know?
Absolutely, Your Honor.
The prosecutor is going to advise you of the charges that have been filed against you and the potential penalties if you're convicted of any of those charges.
Thank you, Judge Clymer. Mr. Hill, count 1 is charges dealing in cocaine or a narcotic drug, a level 2 felony. And that charge reads that Detective Alex Gallegos swears under the penalties of perjury that on or about July 18th, 2025 in Porter County, Indiana, Christopher Hill did possess with intent to deliver cocaine or a narcotic drug classified in Schedule 1 or 2, pure or adulterated, and the amount of the drug exceeded 10 grams. That's a level 2 felony punishable by 10 to 30 years in the Department of Corrections and a $0 to $10,000 fine. Count 2 is dealing in cocaine or narcotic drug as a level 5 felony. That charge reads that on that same day in Porter County, Indiana, Christopher Hill did possess with intent to deliver cocaine or narcotic drug classified in Schedule 1 or 2, pure or adulterated. A level 5 felony is punishable by 1 to 6 years in the Department of Corrections and a $0 to $10,000 fine. Count 3 is possession of cocaine or narcotic drug as a level 3 felony. That charge reads that on that same day in Porter County, Indiana, Christopher Hill did acting without a valid prescription or order of a practitioner, acting in the course of the practitioner's professional practice, knowingly or intentionally possessed cocaine or narcotic drug classified in Schedule 1 or 2, pure or adulterated, and the amount of the drug exceeded 28 grams. A level 3 felony is punishable by 3 to 16 years in the Department of Corrections and a $0 to $10,000 fine. And then lastly, count 4 is possession of cocaine as a level 6 felony. That charge reads that on that same day in Porter County, Indiana, Christopher Hill, acting without a valid prescription or order of a practitioner, acting in the course of his or her professional practice, knowingly or intentionally possessed cocaine or a narcotic drug classified in Schedule 1 or 2, pure or adulterated. And that's a level 6 felony punishable by 6 months to 2.5 years in the Porter County Jail and a $0 to $10,000 fine.
Mr. Hill, do you understand what the charges are against you?
Yes, Your Honor.
Do you understand the potential penalties if you're convicted of any of those charges?
Yes, Your Honor.
Let me advise you of your rights because it's been a while since I've said them. You're entitled to a public and speedy trial. Do you understand that?
Yes.
Your trial could be conducted in front of 12 jurors or me. Do you understand that?
Yes.
You are presumed not guilty. The state must prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You have the right to face and cross-examine every witness. Do you understand that?
Yes.
You have the right to have me issue subpoenas to have witnesses testify for you. Do you understand that?
Yes.
You have the right to remain silent. You can never be forced to testify against yourself. Do you understand that?
Yes.
You have the right to an attorney. If you cannot afford one, I will appoint one for you. Do you understand that?
Yes.
I'm entering not guilty pleas for you on each of the counts, reserving your right to a jury trial and ordering the state to produce discovery, including your criminal history, if any, to you or your attorney. We're not going to address bond. The prosecutor goes first.
Thank you, Judge Clymer. The state did not see a pretrial services report, if there is one in this case. However, the state looked at the defendant's criminal history, notes a conviction for robbery from 2014 Ohio, conviction for aggravated assault 2015 Ohio, conviction for theft 2018 from Ohio, a conviction for drug-related offense from 2020 in Ohio, conviction for some sort of trafficking, I believe narcotics offense from 2021 from Ohio, and a recent conviction for possession of a controlled substance from April of 2025 from Ohio. The defendant listed address is in the state of Ohio. Given that and the nature of these charges, the fact that a level 2 felony faces 10 to 30 years in the Department of Corrections, and given the amount of the drugs involved in this case, being 5 kilograms of cocaine, state would argue that Mr. Hill is a flight risk and a danger to the community by bringing that amount of illegal drugs into our community. State would ask that bond be set at $100,000 surety plus $25,000 cash.
5 kilos?
Yes, Judge.
Mr. Hill, the next lawyer who's going to speak is a lawyer who's here for you for the purpose of bond only, and then his appearance will be withdrawn. Mr. Henson.
Thank you, Your Honor. Mr. Hill, is there an amount of bond you can afford if the court's willing to set one?
Currently, I'm unemployed. I was working as a mechanic, which I'm not really working at the moment now.
Are you not working because of this case, getting picked up on this case, or did you leave that job before this happened?
It was under the table, but yeah, I'm not working now because of what happened. Yeah.
If you were to be released, where would you go?
I've talked to my family, and they're in Ohio, and I can go there.
Do you have anywhere to go that would be in Indiana?
I could maybe make arrangements, but off the top of my head, no.
Okay. If you were to go to Ohio, do you have any job prospects there?
Yes.
What would you do?
Mechanic work.
Okay. If you were to live with your family, would you help support your family after getting that mechanic work going?
I would do my best. Yeah, I would do my best to help because it would be my mother. I'd do my best to help her, and then obviously pay my legal fees and things of that nature.
So I asked this presently, and then I cut you off. Is there any amount of bond that you think you can afford?
At the moment, it wouldn't be me footing the bill. It'd be my family. My family, they don't have very much money. They have some money, but not
okay.
that much.
So here's the issue, Mr. Hill, is that obviously, in order to get out, if the judge isn't going to release you on your own recognizance, then you're going to have to post something. So I need to be able to tell him an idea of what you think is affordable.
Around 5,000.
Okay. Your Honor, we don't have the luxury of a pretrial services report here. Everything you heard out of Mr. Hill's testimony is what I would recite to the court. Obviously, there's a concern as to Mr. Hill's out-of-state contacts, given the fact that he'd be going to Ohio. That said, it sounds as though he does have job prospects and family support. if he were to be released. I don't have access to his criminal history that was recited by Mr. Peterson, given that it was all out of state. The only criminal history I have is the case that we're presently here on, which is obviously significant. That being said, $5,000 is a substantial amount of bond, especially, well, it's the same either way, but to alleviate some of the court's concern, if that was made a surety bond, then a bondsman would be on the hook if Mr. Hill did not, for whatever reason, come back to court. So that may alleviate some of the state's concerns or some of the court's concerns. So ultimately, Your Honor, that's what I'm asking for is $5,000 surety bond. As far as pretrial services goes, if the court felt that was necessary, I'd ask that Mr. Hill be allowed to report via either telephone or some type of video means.
So the purpose of a risk assessment, which I've just talked about this morning, is to determine whether or not the defendant will appear in court. For whatever reason, there was not a risk assessment that was performed in this matter. Regardless of a risk assessment, the court still is to determine an appropriate amount of bond. Both the United States Constitution and the Constitution of the state of Indiana say that a defendant is entitled to reasonable bond. So the question in this case, based upon the allegations,
Sorry, guys, this is way more important than Judge Claymore. Sorry, Judge Claymore, I didn't mean that. Security, how's that baby? How is that baby?
Upon the defendant's residence, based upon the defendant's criminal history, what is a reasonable bond?
$5.
So first of all, the defendant is a resident of the state of Ohio, which is a concern of this court.
This is
Second of all, the defendant allegedly possessed 5 kilograms or approximately 11 pounds of cocaine.
Oh, see, my American brain didn't go that far. 5 kilograms of cocaine. I didn't know how much that was. I just didn't. 11 pounds of cocaine. I understand that. Holy crap. That little boy right there had 11 pounds of cocaine? No, come on. Come on. I bet security's baby that's fighting isn't even 11 pounds. Holy crap. 5 kilos for personal use. Holy crap. Yeah, yes, you're right, Monica. You're right. We have to, yeah, right there it is. That's a lot of cocaine. And I was around in the 80s, and I think that's a lot of cocaine.
Third of all, the defendant was charged with robbery, burglary or attempted burglary, and assorted drug charges going back to August 18th of 2014. Based upon that, I find that the defendant is a flight risk given the fact that he's facing 30 years in Indiana prison, and he's a resident of the state of Ohio.
A little kid.
I set bond in the amount of $100,000 surety and $25,000 cash. Mr. Hill, you are ordered to appear in the following dates, sir. September 10th at 10 o'clock for an attorney status conference. October 22nd at 10 o'clock for an omnibus change of plea hearing. November 26th at 10 o'clock for a final pretrial conference. And January 5th at 1 o'clock for jury selection. Did you hear those dates, sir?
Yes, sir.
I will see you on September 10th at 10 o'clock, sir.
Thank you, Your Honor.
No.
Jeremiah Parker.
Let's do this. Let me address Mr. Hill. Do you have the money to hire a lawyer, sir? Let me put it this way. Now that I've told you you need to come up with $35,000 cash to post the bonds between the surety bond and the cash bond. If you or your family post $35,000 in bonds, are you going to have the money to hire a lawyer? Or can there be a bond assignment? Do you know?
Probably not, Your Honor.
All right. Would you like me to appoint a public defender to represent you?
Yes, Your Honor, that's fine. Because that can be withdrawn at any time, right?
You can do that if you don't like him, but then you don't get to pick who your public defender is. Do you understand that?
Yes, I do, Your Honor. I meant in the case of if I did retain counsel.
All right. So the first date is now stricken. There isn't a date on September 10th, but the dates are now October 22nd at 9:00, November 26th at 9:00, and jury selection is September 5th at 1:00. January 5th, 2026, at 1:00. The jail has contact information for Mr. Chargaloff. He's your public defender. I will see you October 22nd.
Thank you, Your Honor.
Wait. I missed something. His next court date was September 10th, and then the judge just said, I'll see you October 22nd. He's going to miss the September 10th hearing. I know, he is.
Parker.
As soon as we know something, one of us will be reaching out to you.
This is State of Indiana versus Jeremiah Parker, 64 DO2 2410 F2 11045. Also DO2 2412 F2 13081. Defendant appears in custody by video from the Porter County Jail. Defense counsel Denny appears in court representing the defendant. State's present by Deputy Peterson. We're set for a status today.
Your Honor, real quick, can I interrupt? Do you have any more for me? I didn't think so.
I believe that's it, Attorney Henson. Sorry, I didn't advise.
That's okay.
All right,
Thank
so
you.
I've covered you for Elkhart for next week, so apologize for me.
I'll explain it. She won't be surprised, Judge.
All right.
Thank you.
Was there a misdemeanor also charged?
There was.
Okay.
It is 2406 CM 6386.
Okay, I just want to make sure everything's set.
Okay. Mr. Denny's in on all of them.
Yes, Judge. Your Honor, I have a plea. And I went to the jail and had a long chat with Mr. Parker about the agreement. I think it's fair, and I think he might take it eventually. But I wanted to explore, after my conversation, I thought it would be a good idea to possibly explore some alternative options, including drug court. I don't know if that's something the state will consider, but I want to have that conversation with the state. So, Your Honor, I'm asking the court to consider resetting this matter to August 27th at 10 a.m. if that's available, so I can have that conversation.
Any objection?
No objection, Judge.
You take Rule 4 time.
Of course, Judge.
Defendant's motion to continue is granted. Any date previously entered is vacated. This matter is set for a status August 27th at 10 a.m. If there is to be a drug court aspect of this, I don't have a dog in the fight. If that's what the lawyers and the defendant wish to do, I will not get in your way.
Thank you, Judge.
Just saying. We'll see you later, Mr. Parker. Talk to Mr. Denny.
You have a great day.
Yeah, that's fine for now. Thank you.
LeBrandon Wells. This is State of Indiana versus LeBrandon Wells, 64 DO2 2407 F2 7396. Defendant appears in person with defense counsel Denny, who's filling in for defense counsel Barnes. State's present by Deputy Peterson. We're set for a status.
Go ahead, Mr. Denny.
Thank you, Judge. Your Honor, we do have a plea agreement in the file, and I am covering for Attorney Barnes, and Mr. Barnes would like me to reset this for a change of plea hearing on September 24th at 10 a.m. if that's not too far out.
Any objection?
No objection, Judge.
Defendant's motion for a continuance is granted. Any date previously entered is vacated. This matter is set for a change of plea hearing September 24th at 10 a.m. Mr. Wells, you are ordered to appear in person. Do you understand?
Yes, sir.
I will see you then.
We'll send you a letter with that today.
I think bailiffs are always more intimidating when they're standing right beside the door. So a lot of them stand, between these tables and the judge. And I'm sure there is someone over there. But they don't always stand at the door. They do in California. I see them always at the door. But they're always more intimidating when they're blocking your exit. You cannot get out.
That's all, yeah. Do you have Clem Gonzalez?
Oh, yeah. Clem Gonzalez. This is State of Indiana versus Clem Gonzalez, 64 DO2 2503 F5 3218. Also 2406 F6 6641. Defendant appears in person with defense counsel Denny, who's filling in for defense counsel Voga. State's present by Deputy Peterson. We're set for a final pretrial. We have a jury trial scheduled August 11th.
Judge, covering for Attorney Voga, we've got a trial in at least one of these cases set next month. Looks like there's a disc here with a bunch of discovery that Mr. Voga needs to review. My request, Your Honor, is to vacate that jury trial setting and set this for a further status at the court's convenience.
Any objection?
No objection, Judge.
Taking Rule 4 time, Mr. Denny.
Yes, Judge.
How far out should we go?
I would say 45 to 60 days. Would that September 24th date work for you? Yes. Okay, Judge, could we just do that same September 24th date?
The defendant's motion to vacate the jury trial of August 11th is granted. Any date previously entered is vacated. The delay is charged to the defendant. This matter is set for a status hearing September 24th at 10 o'clock. Mr. Gonzalez, you are ordered to appear and wear Packer clothing the next time. No Bears clothing. I'll see you September 24th.
Thank you, Judge.
I don't know about you.
I think we have one.
But I don't care what kind of super fan I am. I would wear Packer clothing the next time, 1000%. Listen, when a judge tells you something, you just do it because it's only going to help you. It's going to make him happy. You could save yourself an extra 4 or 5 months in jail or an extra $7,000 in fines and fees if you're just nice to the judge. Wear Packer clothing.
Last in custody, Nicholas Frazier. This is State of Indiana versus Nicholas Frazier, 64 DO2 2506 F3 7021. Defendant appears in custody by video from the Porter County Jail and is pro se.
Is this a different guy? Or is this the same little boy that had 11 pounds of cocaine? Am I stupid? Probably. I don't pay attention to my videos often.
State's present by Deputy Peterson. We're set for an attorney status today, Judge.
Mr. Frazier, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yep,
Have you been able to hire a lawyer, sir?
No.
So what are your sources of income?
I work for Caribbean Pools. I build swimming pools.
Do you have any family members that could assist you in hiring a lawyer?
Maybe. I'd have to make a phone call.
Let's do this. So I'd given you these dates before. I'd given you today's date for an attorney status conference, an omnibus hearing date of August 27th, and a final pretrial of October 8th. Do you think you'll be able to hire a lawyer before August 27th?
Could I get a public defender?
Your bond remains set at $100,000 cash. Based in part on that, I am appointing Attorney Mark Chargaloff to be your public defender. The dates that I had given you before to appear at 10, you are now ordered to appear at 9. So your next court date will be August 27th at 9 o'clock for an omnibus change of plea hearing. October 8th at 9 o'clock for a final pretrial conference, and November 10th at 1 o'clock for jury selection. The jail has contact information for Mr. Chargaloff. Mr. Frazier, I will see you on August 27th, sir.
Can I ask for a bond reduction?
You can talk to Judge or to Attorney Chargaloff about that. He is now your lawyer. He will file any appropriate motions. Talk to Mr. Chargaloff.
How do I get a hold of him?
The jail has contact information for him. I will see you on August 27th, now at 9 o'clock, sir.
Willie Key. This is State of Indiana versus Willie Key, 64 DO2 2305 F5 4346. Also 2309 CM 8742. Defendant appears in person with defense counsel Camper, state present by Deputy Peterson. Set for a status on this petitioner of probation.
What is the status, Mr. Camper?
Judge, this is a probation violation and it's due to a pending case out of Maryville Town Court. We're disputing those charges. And so I was asking if we could reset this. I think we're going to get a resolution soon in that case and it'll help resolve this case. So I was asking if we can reset this hearing for about 45, 60 days. I think that should be sufficient.
So when is the Maryville matter set?
It's actually set for tomorrow. But we're gonna need some time to work through it, Judge.
Any objection?
No objection, Judge.
The defendant's motion to continue is granted. This matter is now set for a status September 24th at 10 o'clock. Does that work, Mr. Camper?
I believe so, Judge. Yes, that works for me, Judge. Thank you.
Mr. Key, you are ordered to appear here September 24th at 10 o'clock. Do you understand? I will see you then.
Thank you, Judge.
Theodore Staub. This is State of Indiana versus Theodore Staub, 64 DO2 2505 F3 5837. Defendant appears in person with defense counsel Bennett, state's president by Deputy Peterson, set for an initial hearing today.
You can raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
What is your name?
Theodore Staub.
How old are you? Put your hand down. How old are you?
150.
Do you understand English?
Yes.
Are you under the influence of any drug or alcohol?
No.
Do you have any mental or emotional disability?
Yes, but nothing that could affect the trial, I would say.
Do you know what's happening right now?
Yes.
Okay. Have you gone over the penalties and charges with your client, Mr. Bennett?
Yes, Your Honor, we have.
Do you waive formal reading?
We would waive formal reading of the charges and penalties.
Mr. Staub, you have the following constitutional rights. You have the right to a public and speedy trial. Do you understand that?
Yes.
Your trial could be conducted in front of 12 jurors or me. Do you understand that?
Yes.
You are presumed not guilty. The state must prove you guilty beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to face and cross-examine every witness. Do you understand that?
Yes.
You have the right to have me subpoena witnesses to testify for you. Do you understand that? You have the right to remain silent. You can never be forced to testify against yourself. Do you understand that?
Yes.
You have the right to an attorney, and although you have Mr. Bennett, I may appoint one for you if you are unable to afford one. Do you understand that?
Yes.
I'm entering a not guilty plea for you and ordering you to appear on the following dates. September 22nd at 10 o'clock for an omnibus hearing. October 22nd at 9 o'clock for an omnibus hearing. November 26th at 10 o'clock for a final pretrial conference, and January 5th at 1 o'clock for jury selection. And they're all in writing in the order if I've misspoken. So I will see you October 22nd at 10 a.m., sir.
Yeah, just to confirm, it was November 26th.
October 22nd, November 26th, January 5th.
Thank you, Your Honor.
Glenn Peters. This is State of Indiana versus Glenn Peters, 64 DO2 2504 F4 3981. Defendant appears via Zoom. Defense counsel Mullen appears via Zoom. State's present by Deputy Peterson. We're set for a status today. There's also been an addendum of notice of pretrial release violation that was filed just yesterday, July 22nd. And we have a jury trial scheduled September 22nd.
Mr. Peters, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Oh, you're muted. You need to unmute here. You got to push a button to unmute yourself. There you go.
Yes, sir.
Yeah, I can hear you. What is your name?
Glenn Peters,
How old are you?
51.
Do you understand English?
Yes, sir.
Are you under the influence of any drug or alcohol?
No, sir.
All right. Yesterday, the state of Indiana filed a notice of violation of pretrial release. In that, they alleged that you had a drug test sample that was collected on June 25th. It was tested on June 26th, and you allegedly tested positive for amphetamine, methamphetamine, benzo something, carboxy THC, and creatinine. Those drugs would violate your terms of pretrial release and could revoke in your bond or could result in your bond being revoked. Do you understand that?
Yes, sir.
You are entitled to a hearing regarding revoking your pretrial release. Do you understand that?
Yes, sir.
At that hearing, if the state proves those allegations by the preponderance, then your bond may be revoked and you may be held until your case is done. Do you understand that?
Yes, sir.
Mr. Mullen, does your client admit or deny the allegations? All right. So when should we set the notice of violation for pretrial release for an evidentiary hearing, or should we just go forward with the trial on September 22nd?
Well, Judge, we have a pretrial conference August 20th. I suppose even though that is about a month away, state would want to make sure that we would, if we're going to need a lab analyst, I believe this is from an out-of-state entity, that we might just need to get them set up on Zoom. State certainly be open to having the hearing earlier. And I would note too that now this is 3 separate failed drug screens, and I believe the last 3 have all been positive, and that Mr. Peters is supposed to be reporting to pretrial today, although it doesn't seem that he's in the area, and that on June 25th, we were in court. Well, at least we were in court, the defendant was on Zoom, and this was discussed that you're going to...
All right. How long is it, Mr. Mullen, do you have any objection to the lab analyst appearing by Zoom, or do you want the lab analyst to appear in person?
I would object to him appearing by Zoom.
All right. When can the lab analyst appear in person? We'll have a full-blown evidentiary hearing if the state proves that your client tested positive for illegal drugs. Then in all likelihood, his bond will be revoked until the trial. So when will the state, go ahead.
Some circumstances Your Honor is not aware of, and I will talk to Mr. Peterson later on.
All right. So when can we have an
really
evidence?
put this into the record, so.
All right. So the next date in August, let's do this. If there isn't some sort of agreement before the next date in August, then we should have a full-blown evidentiary hearing, and the state can put on evidence regarding a failed drug test.
Okay.
And if they do, then your client should be prepared to go into custody at that time.
Yeah.
We're not messing around anymore. Just saying.
I understand you right, and you're right, Your Honor, but I think there's some circumstances that change.
Well, here, it's alleged that he tested positive almost for a pharmacy.
I just understand.
You're right. He didn't test positive for morphine or heroin or oxycodone.
He tested positive almost for a pharmacy, guys.
We don't.
I know, and I don't think you're going to end up having this hearing. I'll try to resolve this matter in another way, and I'll talk to Mr. Peterson about it, and maybe we could just take this off your table.
All right. So tell me the trial setting is September 22nd. When's the final pretrial? August what?
August 20th at 10 a.m.
All right. This matter is set for August 20th at 10 a.m. if there isn't a resolution.
Can we
And
do
if the
10:30, Your Honor? Just
go ahead, Mr. Mullen. I'm
can we
sorry.
do 10:30 that morning? I'm just going to have a little getting there.
That'll work. 10:30. And if the state failed to present evidence regarding a violation, then the defendant remains free. If the state does, in all likelihood, he doesn't. So
And I'll try to talk to Mr. Peterson today if he.
that might be a good idea. All right. We'll see you in August.
Okay. Thank you. All right. Bye.
Daniel Suprenant. This is State of Indiana versus Daniel Suprenant, 64DO2 2403F3 2430. Defendant appears in person and is pro se. State's present by Deputy Peterson. We're set for a final pretrial conference, and we have a jury trial scheduled August 18th.
JK, thank you so much. Thank you, thank you, thank you. I appreciate it.
All right. So, Mr. Suprenant, when we were last together on June 4th, there was an admit deny hearing regarding violations, and you indicated at that time, once again, that you were going to hire a lawyer. Have you hired a lawyer yet?
I spoke with Russell Brown. I got a meeting with him next Tuesday, and I'm pretty sure he's gonna take the case. He wasn't able to make it today. He said when I spoke with him.
All right. So what we're going to do right now, at least, is affirm the trial setting of August 18th for Rule 4 purposes, but we're going to set it for an additional final pretrial August 4th at 9 o'clock. So your trial of August 18th at 1 o'clock jury selection is affirmed. I'm sorry. Got my days screwed up. Final pretrial August 6th at 9 o'clock. Let Mr. Brown know.
All right.
I'll see you August 6th at 9 o'clock.
Thomas Powell. This is State of Indiana versus Thomas Powell. 64 DO2 1611 F5 10632. Defendant appears in person and is pro se. State's present by Deputy Peterson. We were originally set for a status on a probation violation, and then in the meantime, an addendum to the petition to revoke was filed June 4th of this year.
Tina, they were all saying hi, but I turned the comments off so we could see the last guy. So you didn't see that. But I turned them back on now. So if anybody else says hi to you, you'll see it. He's pondering. He's stealing the other judge's thunder. Oh, it's Sunday. That means that means Judge Eric is not gonna have a docket again today. It's been many
So
days.
the petition to revoke that Ms. Vucic filed says, this is the one filed in May of this year, says that Judge Alexa placed the defendant on probation on February 8th, 2019. Was that actually me? I think Judge Alexa was retired then.
I was sentenced by you, Your Honor, in 17, but I did about 7 years in prison. Well, with jail and prison altogether. I just was released a year and 2-3 months ago.
All right.
So I've been on probation for a year and 2 months.
Because you were originally sentenced by Judge Alexa, and then when you got out, you dealt with me, or did I sentence you?
Well, I was originally in Judge Alexa's court, and then he got sick, and then you took over. So it went from Alexa to you, and you were the sentencing judge.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
What is your name?
Thomas Powell,
How old are you?
44.
Do you understand English?
Yes, sir.
Are you under the influence of any drug or alcohol?
No, sir.
Do you have any mental or emotional disability?
No, sir.
So the state initially filed a petition to revoke on May 6th.
Yes, Judge, and we had the admit deny hearing on that May 28th, and then we're given today's date.
And then there was the
Addendum.
second addendum to the petition.
Yes.
So, Ms. Vucic, I have an interesting question. What's the difference between an addendum to the petition and a second petition? Is there a difference? Or is it because one is resolved before the next?
So I only filed the petition and then the addendum. That's it.
Okay. All right.
So there's no second addendum.
All right. So it's alleged, Mr. Powell, that you had a drug screen that was received on May 22nd and that you tested positive for cocaine in that drug screen. And that probation was asking that I sentence you to 20 days in the Porter County Jail based upon violation of probation. And that your scheduled release date from probation is August 31st of this year. In a petition to revoke your probation, you have certain rights. Your rights differ than in a normal criminal case. You're entitled to a hearing in front of me, not a jury trial. You understand that? At that hearing, the state must prove the allegations against you by the preponderance of the evidence, which means greater than half. Do you understand that? You still have the right to face and cross-examine every witness. Do you understand that? You have the right to have me subpoena witnesses to testify for you. Do you understand that?
Yes, sir. I was trying to hire my own attorney, but I've had some issues. Work's been slow, and then my insurance dropped me. And so I've been paying out of pocket for medical and prescriptions. So like it's been rough for me to hire attorneys. So I was wondering if I could maybe get a public defender possible.
Let's talk about some things first. So are you working somewhere now?
Yes.
Where do you work?
I work at Misfit Tattoo. I'm a tattoo artist. But I don't get paid like by the hour. It's uncommissioned. So if I'm not doing tattoos, I'm not getting paid, you know, so work kind of slowed down. And then with the insurance thing, it's been rough. And then I'm paying for counseling twice a week. I'm going to Fresh Start Counseling and then Better Life Counseling. And I'm paying out of pocket for that too. So
Ms. Vucic, if there is no tolling, which is within the discretion of the court, then Mr. Powell's off date from probation from the charge that I sentenced him to would be August 31st without tolling, but it's tolling right now within my discretion. Is that right?
Yeah, and he has 2 consecutive probation terms after this one. He has 2 other cause numbers he also pled guilty to before he went to prison. And so he has 2 consecutive probation terms. The next one will start after this one, and it's 2 years of probation.
From what court?
Your court?
From yours.
All right. When did you go to prison?
Well, I went to Porter County Jail in 2016 and then fought the case until then I got sentenced in 2019 and then just got out of prison last year in April.
All right.
So altogether, I was incarcerated for like 8 years. And I'm trying to do the right thing. You know, I understand I messed up. I'm going to counseling now, going to meetings.
He likes to ponder off camera.
So 2 more probationary sentences consecutive to the August 31st probation sentence in this matter. The first one is 2 years. Is that right, Ms. Vucic?
Yeah, so you mean the next term? The next
Yes.
term is 2 years, yes.
And then there's another probationary sentence after that as well?
Yes, and that's under the F5833, so that would be the third one. And that one will be 1 year. So he has technically 3 years of probation left when he's done with this current one.
But right now, because of the pendency, unless I say otherwise or rule one way or the other, it could be tolling, which is stretching out the next 3 years.
Correct.
Right? All right. So, Mr. Powell, I'm talking about you and not, I don't want to leave you out of the conversation, but here, let me say a couple of things. So I honestly, I forgot, I recognize you, but I don't remember what your sentence was. So in the most recent petition, what Ms. Vucic is asking is I sentence you to 20 days in jail, based upon testing positive for cocaine. And that was on a date where a collection date of May 22nd. And there was an earlier one where there was a collection date of April 24th, and you allegedly tested positive for cocaine in that one. And in that petition, Ms. Vucic was asking that you serve 10 days in the Porter County Jail. So what she said to me is that in this matter, in this particular case, then I sentenced you to prison. You did that. You're now on a suspended probationary sentence. That suspended probationary sentence is supposed to be up August 31st, at which point you then have a 2-year probation sentence and then a 1-year probation sentence. Does all that sound right to you?
Correct.
And you have a right to deny these allegations. You have a right to contest them. You have a right to a lawyer. And while you do all that, then that also tolls and extends your probation. Perhaps that's within my discretion. Do you understand that as well?
Yes.
Do you do tattoo work on weekends?
Yes.
Do you do tattoo work then 7 days a week?
No, 6 days a week. Wednesday is my only day off.
So. I could do this, I think. If I sentence you to 4 days in the Porter County Jail, which I can't do because you've denied the allegations. If I sentence you to 4 days in the Porter County Jail to be served on Wednesdays, given the level of the offense and the date of the offense, that means with credit time, you would have to do 3 of the 4 days. So if I sentence you to 4 days, and Ms. Vucic can throw things at my screen if I got this all screwed up. If I sentence you to 4 Wednesdays in the Porter County Jail, that means you would do 3 consecutive Wednesdays with the credit time. Then that would consider the 4th. That would be your sentence in this matter. I wouldn't hold probation. You'd be off on probation in this matter, starting your probationary sentences in your next matter, and you don't have to hire a lawyer.
Could I start that next Wednesday?
You could, if there's a factual basis. So it's And then if that happens, then I would sentence you to that. You could begin serving that next Wednesday. Your time would be up before the end of August. I wouldn't toll it. You would be off probation in this sentence and then on probation for the next 3 years on the other two. But then the get out of jail free card, you've used it. You understand that?
Yeah.
All right. Do you admit that you tested positive for cocaine while you were on probation? You weren't supposed to have illegal drugs in your body and you knew you had cocaine in your body.
Yes, Your Honor.
Is that a factual basis, Mr. Peterson?
Yes, Judge, that's sufficient.
All right. I sent
Only cocaine? Huh. That last guy is laughing at you right now. Nope.
you to 4 consecutive Wednesdays in the Porter County Jail beginning July 30th. I don't know what time you're supposed to show up at the jail, but with those 4 days, I think with credit time, that means you would serve July 30th, August 6th, August 13th, and then unless you screw up, which isn't a good idea, between August 13th and August 31st, you would then be terminated from probation in this matter, and your probation begins to run in the next 2.
I would love to see you try to write a paragraph in all caps. I bet you can't even do it. Bet you can't even get your first sentence out.
And then that deals, Ms. Vucic, with both violations. We could still show a denial on the first one and admission on the second one, which is the May drug test. Does that work?
Yes.
And then will you still be supervising?
Go ahead, Micah. Micah, write a sentence in all caps. Go ahead. Just anything you want to say in chat, in all caps, the whole sentence.
Mr. Powell?
Yes.
For the next 3 years?
Yes.
See, she didn't throw bad stuff at you. I can't. Now, I have some patience, but I want you to follow the law. You understand that? All right. So we'll send this over to the jail. You need to report to the jail next Wednesday to serve 3 Wednesdays. And my order will be clear. I don't know what time you're supposed to be there. So, all right.
So just whenever I show up, I just at least 24 hours.
That's the way that we used to do things. So a day is 24 hours. I wouldn't get there at mealtime if it was me, just so you're not screwing things up. But all right.
I'm going to find your mom. I'm going to find your mother. I'm going to find your mother. You're in trouble.
I don't want to see you anymore.
Thank you, Your Honor.
All right. Good luck to you.
You said July 30th?
July 30th passed because this was from, I don't know. It's on my other computer. I don't know when I got this. It was like a little bit ago, like a week ago or something. Okay. Once she sees how many exclamation points you use, you're in double trouble. Oh, man. Okay. Thank you so much for coming out. You're going to be popped right over to OJ. Other than that, I hope you guys have a great Sunday. Clean your house. That's what I'm going to be doing. So if I have to do it, you have to do it. Go clean your house, guys. Have a good day. Bye.
Got these lights that close digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her street sparks so With a giggle, she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a wake there's no alarm. Streaming tales late into the night, her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh